Welcome to Rights and Insights, our Substack here at Fair Fight. We're really excited to welcome everyone who's joining us live and really excited to have this conversation with Joyce Vance and Dr. Carol Anderson. I'll give it a few minutes to allow people to get filtered in before we get started on the conversation. Let me ask just to start us off, Dr. Anderson, Joyce, how are y'all doing today?
Hanging in there, hanging in there.
It's tough times out there right now.
Mm.
But we're really lucky to have both Joyce and Dr. Anderson with us in the fight. We're going to be talking about a really, really important Supreme Court argument that's coming up just next week on October 15th. We're going to be talking about a case called Louisiana versus Calais. It's a redistricting lawsuit coming out of Louisiana. Again, welcome everyone who's just joining. My name is Amr Badat. I'm the Southern States Director and Senior Advisor at Fair Fight. You're joining Rights and Insights, Fair Fight's Substack. We're really excited to have you all, really excited to be talking about this issue. Well, not particularly excited given the subject matter, but really, really important for us to be talking about this issue. I'm joined by Joyce Vance, a professor of law at the University of Alabama and a former U.S. attorney in Alabama, and also Dr. Carol Anderson. She is a historian and professor of African American studies at Emory University, and happy to say she's also a member of the Fair Fight Board. So really, really excited to have both of you joining us today. Um, Again, we're talking about a lawsuit called Louisiana versus Calais. It is a lawsuit related to redistricting coming out of Louisiana after the 2020 U.S. Census. It has to do with Section 2 of the Voting Rights Act, which protects minority voting power in Congress, at state legislatures, at city councils, on school boards. And so we'll dive a little bit into this case. We'll dive a little bit into the broader context of Section 2 and the attacks on voting rights and the attacks on the political power of minorities today. But let me just start out first turning it over to you, Joyce. Can you tell us a little bit about what Louisiana versus Calais is and what the case is about?
So Louisiana v. Callais is a case about redistricting. I think we are all well versed in this by now. Every 10 years we have a census, new data comes out, and then the Hunger Games begin, right? With state legislatures drawing new maps that are supposed to represent voter presence in their state. And of course, if you, like Carol and me, live in the Deep South, you understand that there's a long time trajectory of making it difficult, if not impossible, for Black people to elect candidates of their choice by engaging in gerrymandering that, for instance, until recently, Alabama's maps literally looked like a starfish. There was like a man in the middle of the blackest part of Alabama with a hand reaching into downtown Birmingham and a hand reaching into Montgomery. And like that was what the voting map looked like. It was nuts. And of course, the Supreme Court told Alabama it could not do that. Alabama didn't go quietly, actually. The legislature tried to not listen to the Supreme Court, but the court slapped them pretty firmly. And we now have two Black representatives from Alabama, and amazingly enough, the sky hasn't fallen. We actually have two immaculately well-qualified, fabulous people who I'm proud to call our Congress people. That takes us to Louisiana, where something similar happens. They get the new census data. Lo and behold, Louisiana is court ordered to have two Black opportunity districts. White voters in Alabama challenged that, and y'all will love this if you've not heard this argument before. The white voters challenged it as racially discriminatory towards them because the maps took race into account. The case makes its way to the Supreme Court. It gets briefed and argued last term. And in the final weeks of the term, the Supreme Court says, not so fast. We don't think we're going to decide this one. They take a very unusual step. They hold it over for this new term that just started this past Monday. And on October 15th, this case will be re-argued, this time with the direction from the Supreme Court, in essence, inviting the plaintiffs in this case, the white plaintiffs who claim they're being discriminated against, to argue that Section 2, the last remnant of the Voting Act, is unconstitutional because of considerations of race. So that's about where we'll be in just about a week.
So thank you for that rundown, Joyce, and bringing us up to speed about where we are. I want to highlight just how ridiculous this argument is that Section 2 of the Voting Rights Act, which was intended to protect the political power of Black people and voters of color across the country, is in some way in violation of the 14th Amendment of the Constitution, which was passed after the end of the Civil War to protect the rights of formerly enslaved people. And so, Dr. Anderson, can you talk to us a little bit about the history here of the 14th and 15th Amendments, of the Voting Rights Act? How did we get to this place?
We got here from the Civil War. And then after the Civil War, there was this moment where you had the president, Andrew Johnson, basically saying, oh, I can do what I want to do. And then the radical Republicans in Congress basically slapped him back and said, no, you can't. We have 4 million freed people and they deserve citizenship. They deserve American citizenship. And so that Congress began putting these pieces in place, such as the 14th Amendment and the 15th Amendment. The 14th Amendment was to deal with the Dred Scott decision that said that under no circumstances could Black people be citizens. The 14th Amendment was about birthright citizenship and due process and equal protection under the law. Then there was the 15th Amendment, and the 15th Amendment said the right to vote shall not be abridged on account of race, color, or previous condition of servitude. And the thought behind that was that if Black men, because women couldn't vote then, if Black men had the right to vote, then that would keep the white power structure in check. And that would keep them from trying to debase that Black population. But then we had a Supreme Court. We had massive violence raining down on that Black population. And then we had a Supreme Court that began to gut the pieces that the radical Republicans had put in place. So they began to gut basically the 13th Amendment, the 14th Amendment, and the 15th Amendment with a series of Supreme Court decisions that basically said that Black people didn't have rights. That the federal government had no power to protect those rights. And this is how we end up with the rise of Jim Crow with separate but equal. And we also get the Williams decision that says that two of the major components of massive disfranchisement, the poll tax and the literacy test, did not violate the 15th Amendment because everybody had to take a literacy test and everybody had to pay the poll tax. Actually, that wasn't true, but evidence didn't matter to this court because in 1890, Mississippi had what they called the Mississippi Plan. And that created a massive disfranchisement array of policies. And so we went from 190,000 Black men registered to vote in 1890 to only 8,600 by 1892. Yes. And so the Supreme Court blessed that on high, saying it was not racially discriminatory. And so by the time we get to 1940, only 3% of age-eligible African Americans are registered to vote in the South, only 3%. And the majority of Black people live in the South at that time. And this is what is gearing up, getting us moving toward the civil rights movement and getting us to that cataclysmic event on the Edmund Pettus Bridge in 1965 that dealt with the right to vote because you had massive, massive disfranchisement. So in Dallas County, where Selma, Alabama is, fewer than 1% of age-eligible African Americans were registered to vote in Dallas County, fewer than 1%. In Lowndes County, you had 0% of African Americans registered to vote, but over 100% of whites registered to vote in Lowndes County, Alabama. And those were the kinds of figures that we had throughout the Deep South. That was the catalyst for the Voting Rights Act, because when you had that cataclysm on the Edmund Pettus Bridge, that was so horrific. It was so horrific that you had ABC cutting into its movie of the week, Judgment at Nuremberg, to show the footage of the beatings that were happening when Black people were just trying to argue for the right to vote. And that gives us the Voting Rights Act of 1965. And it was about trying to bring structure to the 14th and the 15th Amendments, trying to undo the damage that that court had done during the Reconstruction era and during the Jim Crow era.
Can I add one tiny little footnote to that? Because I think this history is so fascinating. And as a lawyer, we study the law. I love the historical nuance that you put on it. And I've actually, a tiny moment of self promotion. My first book is about to come out. I've studied this era and written about it. And one utterly fascinating little footnote that I found was, you talk about how they cut in on television to show footage of Selma. And in Montgomery, Alabama, a federal judge named Frank Johnson happens to be watching television. He sees that footage. I think he may have seen it on NBC. I'm not certain which station it is. And then the Selma case ends up in front of Judge Johnson. And he is not deceived by what he's being told by the state of Alabama and ultimately orders federal protection for the marchers. I mean, I think it's just such a lovely little human moment in this whole horrible story.
Mm-hmm.
Yeah, and it's so interesting. I love also, as an attorney, I feel like we need to always be contextualizing in the history all of the work that we're doing, and kind of the picture that you painted, Dr. Anderson, is one of advancement made in the context of voting, in the context of civil rights, followed by backlash, right?
Mm-hmm.
So we had Civil War, Reconstruction, dramatic expansion of Black political power. We had, the first Black U.S. senators from Mississippi in Congress, right? And
Yes.
so, and then followed by this just violent terrorism of Jim Crow, and then the 1890 Mississippi Constitution, which was adopted across the South, poll tax,
Mm-hmm.
literacy tests, and we're seeing the same pattern of progress with the Voting Rights Act, dramatic expansion again of Black political
Mm-hmm.
power, followed by this backlash, this white supremacist backlash to that dramatic expansion. Can you, Joyce? Can you talk a little bit about how I think the central theme here is power, right? It's all about
Yeah.
power and who has power. Can you talk to us a little bit about how this case plays into this back and forth that our country has experienced?
Yeah, I mean, I think you're right when you say it's about power, because the whole point of gerrymandering and this very unusual, right, mid-decade redistricting movement that we've seen President Trump push in states like Texas and elsewhere, it's all about a diminishing party holding on to control, not by winning the hearts and minds of voters, but just through raw power tactics designed to deliver permanent majorities to them. In essence, what this is about is letting politicians pick their voters, not letting voters pick their elected officials. And it really, you do have to understand the history for this to make sense, because you go through the era of Jim Crow, and out of that, one of the legal developments is this mystical sort of notion that voter fraud is being perpetrated by Black people and Democrats. So we have to adopt all of these really restrictive measures to make sure that there's not voter fraud. But the reality is there is no voter fraud, right? And it's all about keeping the wrong kind of people from voting. And so in Alabama, for instance, where John Lewis told the story about Black people facing literacy tests. And listen, this was pretty slick. You had to look at a jar of jelly beans and be able to guess how many jelly beans were in it. And if you got it wrong, then you didn't get to vote. Well, that really is something else. Um, and so you have this sort of evolution, because Shelby County versus Holder, which is the Section 5 case from the Voting Rights Act, guts Section 5 by removing the standards, is a case that comes out of my district. It comes out of the Northern District of Alabama while my Bush predecessor is in office as the U.S. Attorney. It's a traumatic loss. It takes away our ability to challenge measures that are going to burden voting before they go into place. Section 5 was about challenging these laws before they could go into effect and harm people. It's gone. Now what we have left is Section 2. And by the way, the Chief Justice said in his opinion in Shelby County, but you don't need to worry because, for one thing, discrimination has gotten so much better, it's not really a problem. And also there's Section 2. And the big issue with Section 2, which is still, look, a healthy chunk of protection, is that you can't use Section 2 to challenge measures for the most part until they go into effect. And it was primarily used for gerrymandering. While we had Section 5, there's been an effort to expand it and to use it for intentional discrimination. And so now we're seeing, right, the reaction to that. We're seeing this very deliberate effort to find cases where Section 2 can be challenged. And there is a part of my sweet Pollyanna heart that would love to look at Callais and say, oh, the Supreme Court has taken a case with the worst possible facts. You know, you have a horrible history of discrimination. The state of Louisiana was originally on the side of the Black voters. All of the data is there. And you have what essentially amounts to a group of, I don't want to say white supremacists, but of white plaintiffs saying Black people aren't entitled to the same consideration we're entitled to in the political process. You know, good facts make good law, and the Supreme Court has found the best case ever to uphold Section 2 of the Voting Rights Act. But we get absolutely no indication that that's what's going on here. This will be an oral argument to watch carefully, because if the Supreme Court rules against Black voters in Louisiana, it won't affect just Louisiana. It will affect voters nationwide, and we really will be in Hunger Games territory.
So I want to follow up on that, Joyce, because I think it's important for our viewers who have joined us here and just generally the American public to understand what is actually at stake here. We talk about political representation. We talk about how Section 2 has opened up political power to people of color. Can both of you? I would love to hear from both of you about what are the stakes. What are we fighting about here?
I mean, we're fighting about preserving the right to vote. I'd love to hear the historian take.
Yes. So what we're really fighting about is one person, one vote. That's what we're fighting about. Because what gerrymandering does is it dilutes Black political power. It dilutes the political power. It dilutes the political voice of American citizens of color. That's what it does. And so you get this really lopsided piece. And so to me, what their vision is to create what they call a Herrenvolk democracy, like apartheid South Africa, where you have a vast rightless labor pool that's not able to have true representation in government, true policies that emanate from their voice, from their desires, from their needs. And you've got this small layer of folk who get the massive resources that this vast labor pool is generating, and they hoard it. And that's what the vision is. And so if you can dilute that kind of political power, so when you think about what the Jim Crow South looked like, where, again, think about only 3% of age-eligible African Americans are registered to vote in 1940. And this is why World War II is going on. This is when, the whole thing about the Nazis is going on, okay? Only 3% of age-eligible African Americans are registered to vote. And in the 1942 midterms, you had a voter turnout across the board in the South of like 7%. 7% choosing who the federal leaders would be, who the congressmen would be, who the senators would be. 7%. And when you only have to respond to 7% of your electorate, 7% of your population, then you get the kind of warped policies that basically ignore the needs of 93% of your population. That is what's at stake if Section 2 goes by the way, because you have a group in power that sees that the demographics are changing on them. And that demographic change, and because they're not willing to do the work in order to bring those demographics into the fold. So they need to silence them. And by silencing them, that's what you get with gerrymandering. That's what you get with all of these voter ID laws that came to the fore after the Shelby County v. Holder decision. That's what you get with the closing of the polling places in Black and poor communities. That's what you get with the shrinking of the days for early voting. All of those measures are designed to basically silence that electorate. And so that's what's at stake if Section 2 goes by the wayside. And when I think about John Roberts, s- saying that in the Shelby County v. Holder decision, well, at least you're going to have Section 2, if you got discrimination. And then, so it reminds me so much of the Bakke decision. I know this sounds weird. It reminds me of the Bakke decision, which dealt with affirmative action, where they said you cannot use affirmative action to do redress of previous racial discrimination, but you can for diversity, the educational value of diversity. And then what we have after that, we have these serious attacks on the educational value of diversity. And so then we end up with the decision that overturns affirmative action. That's what we're seeing here. We're seeing where they set up a straw man and then they go after that straw man. It's it's it is the Reconstruction Supreme Court courts all over again about how do we weaken the political power, the citizenship. Because we're really talking about citizenship. How do we weaken the citizenship rights of citizens who are not white?
Right. Well, I've been looking at the comments a little bit, and people are really invested in this case, it sounds like. And it also sounds like people are really hungry to know what they can do. And so obviously this case is before the Supreme Court. The argument is next week. Um, can y'all talk a little bit about what folks can do, whether that's showing up at a protest, whether that's calling their representatives? What are folks able to do about not only the attack on the Voting Rights Act that we're seeing play out in the Supreme Court, but generally the attacks on voting that we're seeing play out across the country?
Well, I've got two things that you can do. As soon as you get off of this live stream, and pardon me, I'm going to have to turn to look at it. I want you to Google U.S. Election Assistance Commission, the EAC, and I want you to go to their website. Here's why I want you to go to their website. Many of you have heard of the SAVE Act that was pending in Congress. That's the act that would have made us all prove our citizenship in order to register to vote. Of course, that's tough. It discriminates against poor people because that, in essence, means having a passport. But it also means you have to show up in person. No more voter registration drives. And it applies not just when you register the first time. If you move and you have to re-register, you have to prove your citizenship again. Well, that didn't clear Congress because there was so much opposition. Trump tried to put it in place through an executive order, and a court blocked that, saying he lacked the power. So now there's a move through the Election Assistance Commission, which is a quasi-independent bipartisan group, the federal agency that offers help to states in administering elections. They're trying to implement it there. And it's in a comment period. And we have the opportunity now to go and share our views. And I will tell you that a Stephen Miller affiliated organization has been tremendously successful in driving comments to that website. It's just flooded with negative comments. And what I'm actually going to try to do while Carol is talking is drop a link that you can use to go and make your comments here. But it's so important to do that. And then look, folks, be realistic. I think by the time we vote in 2026, there's a good chance we will have to prove citizenship. So if you have the ability to get a passport, go ahead and do that now. You may need underlying documentation like a birth certificate. You can order that online. Women, if you've changed your name when you've gotten married or divorced, you may have special problems. So start thinking now. Don't wait until it's time to vote.
Thank you so much for calling that out, Joyce. And I want to give a shout out. I saw one comment from Lisa W. that said that she already wrote her comment on the EAC website. So awesome job. I want to see more and more comments come through and to the link that Joyce is going to find for us. Thank you so much for raising that, Joyce. Dr. Anderson.
I think what this really is about is engagement, civic engagement, full civic engagement. So it means if you can get to DC, get to DC. During the arguments. It's also meaning writing your representatives in Congress, because they need to know you're really not cool with the destruction of American democracy. So if they hear that and they know that, and they know that they have a constituency that will take them on at the ballot box, that is so important, because Democracy is being attacked from all sides right now. And the only way that we fight it is by having an engaged citizenry that believes in democracy. And it is that belief in democracy. I call it imagining democracy. It is imagining what democracy could be. And it's that imagining that led those folks on the Edmund Pettus Bridge in 1965. It is that imagining that led the folks who went after Plessy v. Ferguson, imagining what democracy could be and being willing to do the heavy lifting of democracy in order to make that work. So it is engagement. It is staying on your representatives' tails. It is talking to your governor, talking to your state legislators. It is talking to your senators, talking to your congressmen and congresswomen to make sure that they know that you value democracy and they need to value it as well. Because the other piece is that if the Supreme Court does this mess, then we have to then agitate to have legislation put in place that that will undo the damage that they are doing. That is how this democracy will get back on track. And so it requires our full civic engagement to make that happen.
Thank you so much, Dr. Anderson, for that call to action. Thank you, Joyce. Really, really appreciate you both being here. And thank you to the 2,500 people who joined today. And thank you to everyone who has already submitted their comments and who will submit their comments now to the AAC in the coming days. I also want to give folks some more information about the argument that's going to take place next week. It's again going to be held on Wednesday, October 15th. If you are in the DC area or you can get to the DC area, there will be a rally on the courthouse steps before the argument at 9 a.m. So please come out, show the Supreme Court that you do not want Section 2 gutted. You want to protect voting rights for people of color across the country. You want to protect our democracy. Please come to DC if you can. If you can't, you can listen online to the arguments that day. Talk to your friends about it. Talk to your family about it. Make sure that people are aware about what's going on in our country. Thank you again to everyone. This is Rights and Insights. Please subscribe to our Substack. Thank you again, Dr. Anderson. Thank you again, Joyce Vance. Really appreciate y'all being here and hope y'all have a great day.
Thank you all so much.
Thank you. This was wonderful. Thank you.